You've probably heard it a million times in the movies, right? You have the right to remain silent. But what does that actually mean in the real world? Well, today we're going to dive into a fundamental right that acts like a shield between you and the power of the state. It's the right against self-incrimination. We're going to break down what it is, how it protects you, and, just as importantly, where that protection stops.
So let's make this real for a second. Just imagine you're accused of a crime. The pressure is on, it's intense. Can the authorities actually force you to talk? Can they make you give a statement that might be the very thing that gets you convicted?
Well, the good news is the answer is a big, clear, resounding no. The Constitution itself gives you a powerful shield to protect you in exactly that kind of situation.
And that shield, it's not some vague idea. It has a specific name, and it's written right into our Constitution. We're talking about Article 20, Clause 3. This little line of text is the bedrock of your right to silence. And you've really got to look at the exact words here because every single one counts. No person accused of any offense shall be compelled to be a witness against himself. See? Accused, compelled, witness. These aren't just random words. They create the precise boundaries for this protection, and we're about to see how.
Okay, so we've got the rule, but how does this shield actually work day to day? I mean, when can you really use it? Because it's not some magic blanket, right, to stay silent about absolutely everything. It's way more specific than that.
The courts have basically broken it down into a really simple test. Think of it like a checklist. For this Article 23 protection to kick in, you have to be able to say yes to all three of these questions. If even one of them is a no, then sorry, the shield doesn't apply.
So it's like a formula, right? You need 3 key ingredients for the recipe to work. First, you need an accused person. Second, that person has to be compelled, forced or pressured. And third, what they're being forced to give has to be a testimonial statement that incriminates them. If any one of those pieces is missing, the whole thing falls apart. And this brings us to a really crucial point. This shield is strong, but it's not absolute. It has very clear limits. Honestly, knowing what's not protected is just as important as knowing what is.
So let's test these limits with a practical question. We know you can't be forced to say something that could get you in trouble. But what about physical stuff? What about evidence from your own body? Can the police force you to provide your fingerprints or a handwriting sample? And here's where we draw the line in the sand. This protection is all about what's inside your mind, your thoughts, your knowledge, your testimony. What it doesn't protect is the physical evidence that your body can provide. It also doesn't cover anything you say on your own, voluntarily, or statements from someone who isn't even the accused.
So, the key takeaway here is the difference between testimony and physical attributes. The right protects what you're forced to say or write. It does not protect your physical body. That's why you can be legally required to give things like fingerprints, a handwriting sample, or even a DNA sample. The law sees that as just identifying evidence, not forcing you to testify against yourself.
Okay, so that's the theory. But how does this all play out in the real world? Let's take a look at a massive Supreme Court case that really shows this shield in action. This case gave us one of the most powerful ideas in all of criminal law. The Supreme Court said, and I quote, "A coerced confession is inadmissible, even if it's true." Just think about that for a second. It means it doesn't matter if what you said was true or not. What matters is how they got you to say it. So the A.K. Gopalan case basically locked this rule into law. The court's message was unmistakable. If a confession is obtained using force, threats, or any kind of pressure, it's a direct violation of Article 23. And the result? It's simple. That evidence gets thrown out. It's completely unusable in court. Period.
All right, we have covered a ton of ground here, so let's wrap this up and boil it all down into a simple, easy-to-remember guide. Think of this as your quick user manual for Article 23.
Okay, let's lock in the most important points. First, this right belongs to an accused person. It's about not being forced to be a witness against yourself. Second, and this is key, it only protects you against compelled testimonial evidence, the stuff they try to force you to say or write. Third, it does not cover physical evidence like your fingerprints or DNA. And finally, it does not apply to anything you say willingly.
So we're left with this really fundamental question. Article 23 is obviously a vital shield for every individual against the immense power of the state. But at the same time, it creates this constant tension for law enforcement. And it makes all of us ask, where do you draw that line between protecting an innocent person from being bullied into a confession and potentially making it harder to investigate and solve a crime? That's the delicate balance this right is always trying to find.